Hello students, welcome everyone to discussion of RTP of CA Foundation which is applicable for December 23 examination. This is Professor Amit Mishra on behalf of JK Shah classes and I welcome you all to the discussion of RTP. Now I won't take much of your time. Without wasting any time, I'll straightforward go to the discussion of RTP. Now with respect to your RTP for December 23, there is no new amendment in law. I repeat, no new amendment in law. I repeat, there is no new amendment in law. Yes, you heard it right. There is no new amendment. But sir, we saw that RTP, this is for 58 pages. How there is no new amendment? Because whatever amendment they have given in RTP is already covered in your regular classes. Whatever we cover in regular classes with respect to LLP and Company Act. See, first of all, understand one thing. There will be no amendment in Indian Contract Act, no amendment in Sale of Goods Act, and there will be no amendment in the Partnership Act. These three acts are without any amendment since so many years. With respect to LLP and Company Act, these two chapters are dynamic and they keep on changing. But whatever RTP or institute has uploaded for June 23 attempt, the amendment is same in November, that is December 23 attempt as well. So you don't have to worry anything, you don't need to worry about anything. There is no new amendment. Whatever they have given over here, we have already covered in our regular lectures. So for example, if you closely observe the notes which you have with respect to LLP, we have covered everything. We have covered what? Everything. Say for example, if I tell you about new topics which they have introduced in LLP, first of all, see, they have introduced rules for becoming designated partner, which we have already covered. Then they have introduced something called as small LLP. They have introduced something called as small LLP. Now again, small LLP is an LLP whose maximum capital contribution is 25 lakh rupees and maximum turnover is 40 lakh rupees. You remember? Yes or no? So these all topics which they have given in RTP in the form of amendment is already covered in a regular lecture. Say for example, if I show you the amendment they have given for Companies Act 2013, there is only one amendment in Companies Act 2013 with respect to your foundation syllabus, and that is with respect to small company. And everyone knows that maximum paid up share capital of small company is 4 crore rupees and turnover is 40 crore rupees, and this 4 crore can be exceeded till 10 crores by issuing notification. Government will issue notification and they may increase that limit to 10 crores, and this 40 crores can be stretched till 100 crores. These 40 crores can be stretched till 100 crores. Again, government has the power to increase the limit from 4 crores to 10 crores or 40 crores to 100 crores. But as of now, the present limit for small company is 4 crores and 40 crores. I repeat, 4 crores and 40 crores. So small company is a company whose maximum paid up share capital is 4 crore and maximum turnover is 40 crores. Acha, but whenever we will write answer, we will write maximum paid up share capital of small company is 4 crore or such higher amount as may be prescribed not exceeding 10 crores, and maximum turnover is 40 crores or such higher amount as may be prescribed and not exceeding 100 crores. Yes or no? All this topic, whatever 15 pages amendment they have given, that is already covered. That is already covered in your regular lectures, whether you are JKSC student or whether you are non-JKSC student. Whether you are JKSC student or whether you are non-JKSC students, every amendment which they have given to you in this 15 pages amendment sheet of RTP, there is nothing new, that is already been covered in your regular lecture. So you don't have to worry about it. Now, coming to the questions. Now, they have given you 20 questions for practice in RTP. I repeat, they have given you 20 questions for practice. 20 questions for practice in RTP. Yes. And these questions are mixture of. These questions are what, beta? These questions are mixture of direct question and case studies. Direct question and case studies. As you are already aware, you will be asked two type of question in examination. One will be your direct question and the other one will be your case studies. Yes or no? Now, so what I will do, I will not what my approach will be over here, that I will read each and every question with you and I'll discuss answer and concept related to that question as well. Okay, and again I repeat, with respect to amendment, there is nothing new. We have already covered everything in your regular lecture. Okay, now coming to our first question. This question is from Indian Contract Act 1872. I repeat, the question is from the Indian Contract Act 1872. Now what is the question over here? Sheetal was a classical dancer. Okay, Sheetal was a classical dancer. Now Sheetal has entered into an agreement with Sharad Vidya Mandir for 50 dance performances. For how many dance performances? 50. As per the contract, she was supposed to perform every weekend and she will be paid 8,000 per performance. Okay, fine. So we can say that Sheetal has entered into contract with Sharad Vidya Mandir, whereby Sheetal will be performing 50 dance performances and she will be performing every weekend and she will be paid 8,000 per performance. Okay, fine. So Sheetal has promised to Sharad Vidya Mandir that she will be performing. So Sheetal is promiser and Sharad Vidya Mandir is promisee. Correct? Sheetal is promiser and Sharad Vidya Mandir is promisee. Okay. Sheetal has promised for performance to Sharad Vidya Mandir. Therefore, from performance perspective, Sheetal will be promiser, Sharad Vidya Mandir will be promisee. Okay, fine. Now, after a month, she was absent without informing due to her personal reason. She had some reason due to which she was absent. She didn't perform on that particular weekend. Now, we have been asked whether the management of Sharad Vidya Mandir has the right to terminate the contract. Second question is, if the management of Sharad Vidya Mandir informs Sheetal about its continuance, can the management still resign the contract after a month on this ground subsequently? And can the Sharad Vidya Mandir claim damages that it has suffered because of its breach in any of the above case? Okay. Now, if you guys are able to recollect, the question given here is from Unit 4 of the Indian Contract Act 1872, where we have section 39. In section 39, promisee is ready to perform his part, but promiser is refusing to perform. I repeat, under section 39, promisee is ready to accept the performance, but promiser is not performing his part of promise. So promisee has the option, either he can continue the contract or he can resign the contract. I repeat, either he can continue the contract or he can resign the contract. Okay. Now, so the first question over here is whether management of Sharad Vidya Mandir has the right to terminate the contract. The answer is yes, because promisee, that is Sharad Vidya Mandir, was ready to accept the performance, but Sheetal refused to perform. Now Sharad Vidya Mandir has every right to terminate the contract first. Okay, so the answer will be yes. Now, if the management of Sharad Vidya Mandir informed Sheetal about its continuance. Okay. Now, in second situation, they are saying that Sharad Vidya Mandir has decided to continue the contract. I repeat, promisee has the option either to resign or either to continue. In first case, we have been asked, can Sharad Vidya Mandir resign? The answer is yes. In second case, can Sharad Vidya Mandir continue? Yes. And if they are continuing, can they subsequently resign, yani cancel? Can they subsequently resign? That means cancel the contract subsequently? The answer is no. If they decide to continue the contract, then subsequently they cannot resign the contract for that particular reason. And third, can Sharad Vidya Mandir claim damages? Acha. For this, I will like to introduce section number 75. Acha, under section 75, if any party rightfully resigns the contract, then such party is entitled to claim damages. So in this particular situation, Sharad Vidya Mandir is not a party in default. Sharad Vidya Mandir is acting in good faith and they are rescinding contract because of breach by Sheetal. And Sharad Vidya Mandir is absolutely correct on its stand. So therefore Sharat Vidya Mandir can claim damages. Yes, they can claim what? Damages, and for that I will introduce section number 75. Okay. Now one more thing, Sheetal, whatever contract is entered between Sheetal and Sharat Vidya Mandir is a contract of personal skill, personal nature. Is a contract of personal skill and personal nature. So therefore it should be performed by promisor himself, and it is given under section number 40. It is given under section number 40. So we can incorporate 3 sections in this particular answers, provided if you remember section. Okay. Now 3 sections: section 39 where promise is ready to accept performance but promisor is not performing. Section 75, if any party rightfully signed the contract, they are entitled to claim damages. And section number 40, if the contract involves personal skill, then promisor should perform himself. Now if I look at the answer of this particular question, again they have given those 3 sections. Now if I look at the answer of the given question, see, they have quoted section 39 where promise is ready to accept but promisor is not performing, and they have quoted section 40 also where if the contract involves personal skill, promisor should perform himself, and again they have quoted section 75 where a party rightfully resigns the contract, they are entitled to claim damages. Now so therefore in the instant case, Sheetal could not perform and Sharat Vidya Mandir can terminate the contract. The answer to the first question. Now the answer to the second question is, in the second situation, the management of Sharat Vidya Mandir informed Sheetal about the continuance. Okay, so now they cannot resign the contract after a month. And third, yes, as per section 75, Sharat Vidya Mandir can claim damages. Easy, easy, simple first question. Okay, fine. Now second question is, again this question is related to unit 3 of the Indian Contract Act 1872, and to be more precise, with respect to competent to enter into contract. Competent to enter into contract. Competent to enter into contract, and it has been specified under section 11. Section 11. Now as you know, parties who are competent to contract, competent to contract are major, sound mind and not disqualified by law. It means minor, a person of unsound mind and a person who is disqualified by law cannot enter into contract. Now the persons who have capacity to enter into contract is specified under section 11 of the Indian Contract Act 1872. Okay, fine. Now the question over here is, Paridhi is a minor. Paridhi is a minor and she falsely represented her age and entered into an agreement with a laptop dealer. Mr. Mittal. Okay. So we have 2 parties. One is Paridhi, who is minor but she has falsely represented her age. And the other party is Mr. Mittal, who is the owner of MP laptops. Okay, fine. Now, Paridhi somehow purchased laptop on credit for rupees 60,000 on 1st August 2022, and she promised to pay back the outstanding amount with interest of 16% per annum by 31st July 2023. So I can say that Paridhi has purchased laptop on credit and the credit period is 1 year, and she will be repaying 60,000. She will be paying 60,000 along with interest of 16% per annum. Okay. She told him that in case she won't be able to pay the outstanding amount, her father Mr. Ram will pay back on her behalf. Okay. So the question till now is saying that Paridhi is a minor but she falsely represented her age and purchased a laptop from Mr. Mittal worth rupees 60,000 for a credit of 1 year, and the interest which Paridhi will pay is 16% per annum. Okay? Acha. Further, Paridhi says to Mr. Mittal that Mr. Mittal, in case I won't be able to pay your amount, don't worry, my father Mr. Ram will pay. Okay, fine. After 1 year, when Paridhi was asked to pay the outstanding amount with interest, she refused to pay the amount and told the owner that she is minor and now he cannot recover a single penny from her. And Paridhi is going to become major from 1st January 2025, and only after that the agreement can be ratified. So this is the question in front of us, and now we have been asked, explain by which of the following ways Mr. Mittal can succeed in recovering the outstanding amount with respect to the Indian contract. Now first of all, you need to understand that a contract entered by a minor, a contract entered by minor is void ab initio. Is void ab initio. It means void from the beginning. So if I am a minor and I am entering into contract with any person, the contract will be void ab initio. It doesn't matter whether I have falsely represented my age or not. If I am minor, contract is void ab initio. First of all. Second is law of estoppel. Law of estoppel does not apply on minor. Law of estoppel does not apply on minor. I repeat, law of estoppel does not apply on minor. Achha, what do you mean by estoppel? Estoppel means once accepted cannot be denied. Once accepted cannot be denied. So if you have accepted something, subsequently you cannot deny that I have not said that particular thing. Okay? Now, but this does not apply on minor. That means minor can deny what he has accepted earlier. So for example, in this case, Paridhi admitted that she is major and entered into contract with Mr. Mittal. Now later on, can Paridhi say that when the contract was entered, I was minor? Yes. Can she go back on her statement? The answer is yes. The answer is yes. Yes. Achha. One more thing. Guardian of minor are not liable for the personal contracts of the minor. Guardian of minor are not liable for personal contracts of the minor, and contract entered by minor cannot be ratified when minor becomes major. Yes or no? Yes or no? Why? Because the contract was void ab initio. Now in this case, can Mr. Mittal file a case against Paridhi, a minor, for recovering the outstanding amount? The answer is no, because there is no contract. Contract is void ab initio. Second, by filing a case against Mr. Ram, father of Paridhi, for recovering outstanding amount? The answer is no, because guardian of minor are not liable. And third, by filing a case against Paridhi, a minor, for recovering of outstanding amount after she attains majority? The answer is no. Again no. Why no? Because the contract was void ab initio and it cannot be ratified after Paridhi becomes major. Easy, simple, very simple question. The section that we are going to quote over here is section number 11, competent to contract or capacity to contract. Now if I look at the answer of this question, see, again they have quoted section number 11. A minor is not competent to contract and an agreement with minor is void from the very beginning. We will write Latin word void ab initio. It will leave a good impression in the eyes of examiner and will get good marks. Now regarding the answer, Mr. Mittal will not succeed in recovering the outstanding amount by filing case against Paridhi. Minor cannot bind parent or guardian. That means Mr. Mittal cannot sue Mr. Ram as well. And no ratification after attaining majority. Easy, simple. Now, moving ahead, we move to third question. Rohan. We have Rohan with us. Rohan has found a wallet in a restaurant. Okay, Rohan has found a wallet in a restaurant. Now he inquired all the customers present there, but the true owner could not be found, and then he handed over the same to the manager of the restaurant to keep the wallet till the true owner is found. Okay, Rohan is a very nice person. He has found wallet belonging to someone else. That means, can I say Rohan is founder of lost goods? Rohan is founder of lost goods, or we can say Rohan is finder of lost goods. Rohan is finder of lost goods. Rohan is such an ethical person. He found wallet. He inquired all the customers present in the restaurant or hotel, whatever restaurant is given. So he inquired all the customers in restaurant regarding who has the ownership of that particular wallet, or to which person that wallet belongs to. But somehow he ended up with nothing. That means the true owner was not found. Then later on, Rohan handed over that wallet to the manager of the restaurant. Okay, fine. Now after a week, Rohan went back to the restaurant to inquire about the wallet. Manager refused to return it to Rohan, saying that it did not belong to him. It did not belong to him. In the light of the Indian Contract Act 1872, can Rohan recover the wallet from the manager? Okay, now. The question here pertains to section number 71, which talks about finder of lost goods. I repeat, which talks about finder of lost goods. Now, one very important thing to note about finder of lost goods is, finder of lost goods is a person who has found goods belonging to someone else. Finder of lost goods is a person who has found goods belonging to someone else. Now, finder of lost goods is not liable to pick the goods up, but if he picks the goods up, if he picks them up, he is liable to take care of the goods in the same manner as a man of ordinary prudence would have taken in his own case. In the same manner as a man of ordinary prudence would have taken in his own case. That means finder of lost goods should take care of the goods. And one very important aspect under finder of goods is that finder of lost goods can keep the goods with himself against the entire world except for true owner. Except for true owner. Which means that if I am a finder of goods, I have every right to keep the goods with myself, and I will retain the goods with me till true owner is found. Till true owner is found. Now in this given case, Rohan is founder of lost goods, or Rohan is finder of lost goods. So Rohan has every right to keep the goods with himself against the entire world except for true owner. Which means that only if true owner comes to Rohan, then only Rohan will, which means Rohan will return the goods only to true owner and not to any other person. So in this case, manager must return wallet to Mr. Rohan. Although wallet did not belong to Mr. Rohan, but still Rohan will get the wallet back because he is finder of lost goods, and any person who is liable to take care of the goods after owner is no one but finder of lost goods. So finder of lost goods can keep the goods with himself against the entire world except for true owner. Simple, easy. Now, if I look at the answer of this particular question, again they have quoted section number 71. A person who finds the goods belonging to another and takes them into his custody is subject to same responsibility as if he were a bailee. Bailee means transferee who has received the goods. The person who transfers the goods is bailer. The person who receives is bailee. Now, I hope you have heard about contract of bailment. Contract of bailment. Again, contract of bailment is a contract where one person transfers the possession of movable property to another person for some specific purpose, and after the purpose is over, goods are returned back. Goods are what? Returned back. Now, in this particular situation, finder of lost goods will be liable as bailee. Bailee means a person who has received the goods. Now, bailee will have to take care of the goods. Now, so thus finder of lost goods has to take proper care of the property. No right to appropriate the goods. That means he cannot use goods for his own personal purpose, and to restore the goods if the owner is found. That means if he finds the true owner, he will have to give the goods back to the true owner. Now, in the lights of the above provision, the manager must return the wallet to Rohan, since Rohan is entitled to return the wallet found against everybody except the true owner. Simple, easy, done. Okay, fine. Now, moving ahead to fourth question. Now, fourth question is very interesting. Very interesting. Fourth question relates to section number 59 to section number 60, which is nothing but appropriation of payments. Appropriation of payments. Appropriation of payments. I repeat, section number 59 to 61, which talks about appropriation of payments. Appropriation means adjustment. Appropriation means adjustments. I repeat, appropriation means adjustments. Okay, fine. Appropriation means adjustments. Okay, fine. Section number 59 to 61. Now, in the given situation, Mr. Sohan, a wealthy individual, provided a loan of 80,000 to Mr. Mukesh on 26 February 2021. Okay. So we have Mr. Sohan with us. we have Mr. Sohan with us. He has given loan of rupees 80,000 80,000 to Mukesh. To Mukesh. Okay, guys. Mr. Sohan has given loan of rupees 80,000 to Mr. Mukesh, and this loan was given on 26th February 2021. 26th February 2021. Okay, fine. Now, the borrower Mr. Mukesh asked for a further loan of 1,50,000 from Sohan, from Mr. Sohan. Acha, Mukesh has already taken a loan of rupees 80,000 from Sohan. Now, Mukesh is asking further loan of 1,50,000 from Mr. Sohan. Now, Mr. Sohan agreed but provided the loan in parts on different dates. Okay. Mr. Sohan is very wealthy. He has so much of money. He has agreed to give further loan of rupees 1,50,000, but not together. He has decided to give loan in parts on different dates. So he provided 1 lakh on 20th February and 50,000 on 3rd March. Okay. So Mr. Sohan gave another loan of rupees 1 lakh to Mr. Mukesh. This loan was given on 28th February 2021, and he gave another loan of rupees 50,000 on 3rd March 2021 to Mr. Mukesh. Now, okay, fine. Now on 10th March, Mr. Mukesh, while paying off part 75,000 to Sohan, insisted that the lender should adjust 50,000 towards the loan taken on 3rd March and the balance towards the loan taken on 26th February. But Mr. Sohan objected to this arrangement and asked the borrower to adjust in the order of the date of borrowal of funds. Okay, fine. Okay, fine. Now, in the given situation, Mr. Mukesh is borrower. Mr. Mukesh is borrower and Mr. Sohan is lender. Okay. Mr. Sohan is lender and Mr. Mukesh is what? Mr. Mukesh is borrower. Simple, easy, done. Now. Mr. Sohan paid 75,000 to Mukesh. Oh, sorry. In fact, it is contrary. Mukesh paid 75,000 to Sohan. Mukesh paid 75,000 rupees to Sohan, and this payment was made on 10th March 2021. 10th March 2021. Acha. We can also call Mukesh as debtor and Sohan as creditor. We can also call Mukesh as debtor and Sohan as what? Creditor. Okay, fine. Now. Mukesh has paid 75,000. So, the provision of section 59 to 61 triggers when there are several debts, not single debt. There are several debts or several loan between same debtor and same creditor. Yes or no? And debtor repays an amount which is not sufficient to discharge entire loan. Say for example, in this case, the entire amount of loan which Mukesh has taken from Mr. Sohan comes to 2,30,000. 2,30,000. If I aggregate all three loans which is given by Mr. Sohan on different dates. But here Mr. Mukesh has paid only 75,000, and now Mr. Mukesh is insisting that his 75,000 should be adjusted against 50,000 loan and balance should be adjusted against the loan which was taken on 26th February 2021. Can Mr. Mukesh say so? Can Mr. Mukesh insist on this to Mr. Sohan to adjust the loan according to Mr. Mukesh direction? The answer is yes. The answer is yes. And this has been specified under section 59, where it has been specified that appropriation of payment. Appropriation yani, appropriation means adjustment of payments as per directions of debtor. As per directions of debtor. As per directions of debtor. So the first question here is whether the contention of Mr. Mukesh is correct. The answer is yes. Mr. Mukesh can say that please adjust 75,000 against third loan and then against first loan. Yes, Mr. Mukesh can say so. Now, second, what would be your answer in case the borrower, that is Mr. Mukesh does not insist on such order of adjustment of repayment? Now, if Mr. Mukesh remains silent regarding adjustment of debt, then section 60 says that creditor will specify. See, as per section 59, debtor should specify the order in which debt should be adjusted. And in case debtor fails to specify, then it is the responsibility of creditor to specify that in which order he is going to adjust the payment. Yes. So if borrower, that is Mukesh, does not specify anything, then the debt will be adjusted as per the discretion of debt will be adjusted as per the discretion of Mr. Sohan. That is, if debtor does not specify anything, then creditor will specify. If debtor does not specify anything, then creditor will specify. And last but not the least, what would be the mode of adjustment appropriation of such part payment in case neither Mr. Sohan nor Mukesh insist any order of adjustment on their part? Now, if neither Mr. Sohan nor Mr. Mukesh specify anything, then the provision of section 61 will be applicable, and section 61 says that debt will be adjusted according to time. That is FIFO, first in, first out. Yes or no? Simple. So the provision of section 59, 60 and 61 will be applicable in this particular question, and this was very easy question but lengthy question. If this type of question comes in your examination, it will consume your time because it will take time to read the questions, because they have given dates, they have given amounts, they have given everything. Okay. So in order to make sure that we can attempt this question effectively, please make sure that you have done revision very effectively. Yes or no? Now, if you look at the answer, see, the topic is appropriation of payments, and they have quoted three sections: section number 59, section number 60 and section number 61. Wait, I'll show you. Section number 59, section number 60 and section number 61. Easy, simple, done. Acha, four questions are done. Now coming to our fifth question. Again, fifth question says that state with reasons whether the following agreements are valid or void as per the Indian Contract Act 1872. Okay. So now we have been asked that please advise whether the contract is valid or void. Okay, fine. Now, where two courts have jurisdiction to try a suit, an agreement between the parties that the suit should be filed in one of these courts alone and not in the other. Now let me tell you, there is something called a section 28. There is something called a section number 28, which says that agreement in restraint of legal proceedings is void. Again, I am repeating, this question is from Indian Contract Act 1872. So whenever I am quoting section number 28, that means this section 28 is from Indian Contract Act 1872. Yes or no? Now, and as per section 28, an agreement in restraint of legal proceedings is void. That means I cannot restrict a person to file a legal case against me, and similarly the other person cannot restrict me to file case against him. But there are two exceptions. First exception is arbitration, and the second exception is contract specifying courts. That means if two courts have jurisdiction to try a suit, that means my case can be filed either in court X or either in court Y. Example, my case can be filed either in court X or either in court Y. So if parties to the contract decide that we will file case in court X only, or we will file case in court Y only and not in other court, then such restriction is valid. Then such restriction is valid, and contract will also be what? Valid, because it is an exception to section 28. It is an exception to agreement in restraint of legal proceedings. Second, X offered to sell his Maruti car to Y. Okay. Y believes that X only has WagonR car, but agrees to buy it. Now can I say this will be void contract? Void contract, because there is no consensus ad idem. There is no consensus ad idem. There is no meeting of mind. There is no real consent only between the parties. So it will be void contract. It will not be valid contract. Third, X, a physician and surgeon, employs Y as an assistant on a salary of rupees 75,000 per month for a term of 2 years. For a term of 2 years, and Y agrees not to practice as surgeon and physician during these 2 years. During these 2 years. Okay, fine. Again, this is an exception to section 27. 27 says that agreement in restraint of trade is void, but one of the exception of 27 specifies that in case of employment contract, employer can restrict employee, but that restriction should be reasonable. So here X has put reasonable restriction. X has put reasonable restriction on Y, and therefore it will be a valid contract. It will be a valid contract. Simple, easy, done. Okay. Achha. Now moving forward to sixth question. Sixth question is Mr. Seth. Okay, Mr. Seth is an industrialist, has been fighting a long drawn litigation with Mr. Raman. Okay, so Mr. Seth and Mr. Raman are fighting with each other. Obviously, fighting in the sense is litigation, that is legal case. Okay, now to support his legal campaign, Mr. Seth, to support his legal campaign, Mr. Seth enlists the services of Mr. X, a legal expert, stating that an amount of 5 lakh would be paid if Mr. X does not take up the case of Mr. Raman. Now, please understand what is happening over here. Mr. Seth offers rupees 5 lakh to Mr. X. Mr. X is a legal expert. Mr. X is a legal expert. Achha. Mr. X is a legal expert. Now, Mr. Seth has offered 5 lakh rupees to Mr. X if Mr. X does not take case of Mr. Raman. Understand, Mr. Seth is not giving 5 lakh to fight his own case. Mr. Seth is giving 5 lakh to restrict Mr. X from fighting on behalf of, for fighting case on behalf of Mr. Raman. So don't you think this is a clear case of agreement in restraint of trade? Agreement in restraint of trade, section number 27 of Indian Contract Act, which says that a person cannot restrict another person from exercising any lawful business, profession, etc. Now, the fun fact is, or the fun part is, Mr. X agrees, and at the end of the litigation, Mr. Seth refused to pay. Mr. X agreed that he will not take case of Mr. Raman. But, after the end of litigation, Seth refuses to pay rupees 5 lakh to Mr. X. Now the question over here is, can Mr. X recover the amount? The answer is no, because the contract between Seth and Mr. X is void. Agreement in restraint of trade is void, and therefore no party can file case against each other for recovering anything. Simple, easy, done. Can I say X is dumb over here? X is dumb over here. No person can restrict you. How can X be a legal expert if he can't understand a simple situation, a simple thing, that agreement in restraint of trade is void? No one can restrict Mr. X from taking up anyone's litigation. Now, if Mr. Seth is offering 5 lakhs, then that is not valid. It is void, and Seth cannot recover even a single penny from Mr. X, cannot recover even a single penny from Mr. Seth. See, if I show you the answer, according to section 27 of the Indian Contract Act, an agreement by which any person is restrained from exercising a lawful profession, trade or business of any kind is to that extent void. And in the given case, Mr. Seth in litigation with Mr. Raman since long, and Mr. Seth has restricted Mr. X from fighting case on behalf of Raman. So as section 27 makes the contracts in register of trade void, the contract between Mr. Seth and Mr. X is also void, and hence Mr. X cannot recover the amount promised by Mr. Seth. Easy, simple, done. Okay. Coming to our seventh question. Now, seventh question is not a case study. It is more of a direct question. It is a direct question. I repeat, it is not a case study. It is a direct question. Now, when I say direct question, that means you will have to write answer in point wise. But let us see what the question is asking. See, what are the consequences of the destruction? What are the consequences of the destruction of specified goods before making of contract and after the agreement to sell under the Sale of Goods Act 1930? Now, all the questions of Indian Contract Act 1872 in this RTP has been over. Question number 1 to 6. Question number 1 to 6 were from Indian Contract Act 1872. Now, with respect to question number 7, it has been asked from Sale of Goods Act 1930, where they are asking what is the effect of destruction of goods. Destruction of goods before sale and after agreement to sell and before sale. Okay, fine. Now, if goods are destroyed before sale, I repeat, if goods are destroyed before sale, then contract of sale become voids. Contract of sale becomes void, first. And the second is risk of loss. Risk of loss is with seller. Because before sale, who has the ownership? Seller has the ownership. And the golden rule is risk follows ownership. So before sale, owner is seller. So who will bear the risk? Seller. And contract of sale will be void. But if goods are destroyed after agreement to sell but before sale, goods are destroyed after agreement to sell, ATS is agreement to sell but before sell, then between this period, now contract of sale will become void. I repeat, contract of sale will become void. Why? Because goods are now destroyed. Goods are no more answerable to the description. So goods are destroyed, contract will become void. Now, again, risk will fall on seller only. Because ownership is not yet transferred to buyer. But one more thing to watch out here is that seller, or we can say aggrieved party, can claim damages from defaulting party. I repeat, aggrieved party can claim damages from defaulting party. Yes or no? Easy, simple. Now, yes. So if I look at the answer, one more thing to add over here is, if goods are destroyed before sale, the consequences are given under section 7. And if goods are destroyed after agreement to sell but before sale, the consequences are given under section 8. Now, if you can see the answer, they have quoted section number 7 and section number 8. Yes or no? Easy, simple. Now, next question. Question number 8. Again, it is more of a direct question. Again from Sale of Goods Act. Direct question, and again from Sale of Goods Act. Now, what are the implied conditions in a contract of sale by sample? Now, if you remember sale by sample, it is given under section 17. Sale by sample is given under section number 17, where it has been clearly specified that if you are selling any goods by sample, then the bulk shall correspond with the sample and the buyer should get an opportunity to inspect the goods, and goods shall be free from any defect. Goods shall be free from any defects. And which defects? That is latent defect. goods shall be free from any latent defects. When I say latent defects, it means defects which cannot be easily seen. Defects which cannot be easily seen. So goods shall be free from latent defect. See, there are two types of defect. One is latent, the other one is patent defects. Now patent defects can be easily seen. So if there is any patent defects, that buyer can examine himself. But if there is any latent defects, if there is any hidden defects, that buyer would not be able to examine. Yes or no? So in that particular situation, if you are selling goods by sample, section 17 will trigger and the bulk shall correspond with sample. Second, buyer should get an opportunity to inspect. And third, last but not the least, goods shall be free from any latent defect. Okay, fine. Achha. Next, also state the implied warranties. Now there are four types of implied warranty. If you remember, warranty as to undisturbed possession. That means once seller has sold the goods, he cannot disturb the possession of the buyer. Buyer has the right to enjoy the goods in any way he likes. Second, warranty as to non-existence of any encumbrances. Encumbrances means burden. There should be no burden on the goods which is sold. The goods sold shall not be pledged or mortgaged with someone else. And third, warranty as to quality or fitness by usage of trade. That means whatever goods are sold, it should be fit for use. And last but not least, it is seller's duty to disclose the dangerous nature of goods to the buyer. It is seller's duty to disclose the dangerous nature of goods to the buyer, and if seller fails to do so, buyer can claim damages. Simple. So four types of warranty and implied condition with respect to sample. Easy, simple, very simple, direct question, straightforward question. Now, question 9 is very interesting over here. Very, very interesting. Question 9. We have Shubhangi with us. Okay. Shubhangi went to a jewelry shop. Shubhangi went to a jewelry shop and asked the sales girl to show her diamond necklace. Okay, okay. So Shubhangi needs diamond necklace. Okay, okay. Diamond necklace with sapphire stones. With which stones? Sapphire stones. Okay, fine. Okay. Now the jeweler told her that we have a lot of designs of diamond necklace but with blue stones. Okay. Now the requirement of Shubhangi was diamond necklace with sapphire stones. But jeweler shop owner or the salesperson, whoever is there, is telling that we have so many designs. We have so many designs but with blue stones. We have so many designs in diamond but with blue stones. If she chooses for herself any special design of diamond necklace with blue stones, they will replace blue stones with sapphire stones, but for the sapphire stones they will charge some extra cost. Okay. Now, the situation is very simple over here. Shubhangi wants diamond necklace with sapphire stones, but jeweler shop has diamond necklace with blue stones. So what diamond necklace offers is, Shubhangi, you choose any design which you like. What we will do, we will replace blue stones with sapphire stones. We will replace blue stones with sapphire stones. Okay, we will replace blue stones with sapphire stones. Wait. Sapphire stones are expensive than blue stones. So whenever we will replace blue stones with sapphire stones, you will have to pay extra charges. You will have to pay extra charges. Easy, simple. Now, Shubhangi selected a beautiful designer necklace and paid for it. She also paid extra cost of sapphire stones. Okay, fine. Now, the jeweler requested her to come back after a week for delivery of the necklace. Okay. Hey, can I say, in this particular question, a contract is there between Shubhangi and that jewelry shop owner. There is a contract of sale. Now, contract of sale is a contract where seller transfers or agrees to transfer property in the goods to the buyer for a price. Contract of sale is a contract where seller transfers or agrees to transfer. Seller transfers or agrees to transfer property in the goods to the buyer. to the buyer for a price, है ना, to the buyer for a price. I repeat, to the buyer for a price. Yes or no? Yes or no? To the buyer for a price. To the buyer for a price. Easy, simple, easy. Now, understand. In our situation, jeweler's shop will be delivering necklace 1 week later. 1 week later. That means the contract of sale between jeweler shop and Shubhangi is nothing but agreement to sell, because contract of sale can be of two types: sale and agreement to sell. Sale and agreement to sell. And in case of agreement to sell, property in the goods, that is ownership in the goods, is not transferred immediately, but it is transferred in future. It is transferred in future. Okay, fine. So there is agreement to sell between Shubhangi and jewelers, and contract of sale is given under section number 4. Easy, simple. Now, when she came after a week to take the delivery of necklace, she noticed that due to sapphire stones, the design of necklace had been completely disturbed. Oh no. Whatever beautiful design Shubhangi had selected, the design is now damaged because of sapphire stones. Now she wants to terminate the contract and thus ask the manager to give her money back. But he denied for the same. Okay, so manager is denying. Now state with reasons whether Shubhangi can recover the amount from the jeweler. The answer will be yes. If you closely read the answer given by them, on the basis, see, first of all they have quoted section number 4. Section number 4, that is contract of sale, in which they have quoted sale and agreement to sell. Now, on the basis of the above provision and facts in the given question, it can be said that there is an agreement to sell between Shubhangi and jewelers and not a sale. Even though the payment was made by Shubhangi, the property in the goods can be transferred only after the fulfillment of conditions fixed between the buyer and the seller. And as due to sapphire stones, the original design is disturbed, necklace is not in the original positions, and hence Shubhangi has the right to avoid the agreement to sell and can recover the price. That is, Shubhangi can terminate the contract and she can ask her money back. Second question is, what would be your answer if jeweler says that he can change the design but he will charge extra cost for the same? The answer is, why Shubhangi should pay extra cost? She has already paid extra cost for replacing blue stones with sapphire stones, and it was jeweler's shop responsibility, that salesman's responsibility, to make sure that design was in order, which was specified by Shubhangi. So if jeweler's shop wants to rectify the design, for that Shubhangi is not liable to pay even a single extra penny. So if jeweler offers to bring the necklace in original position by repairing, he cannot charge extra cost from Shubhangi. Even though he has to bear some expenses for the repair, he cannot charge it from Shubhangi. Easy, simple, done. Now, many of the students get confused in this particular question. They think, sir, this is relating to description, implied condition with relating to description, sale by description, implied condition as to description, which is wrong, because the agreement, the contract between jewelers and Shubhangi was with respect to that goods which was not in existence only. See, in order to describe the goods, I should have goods with me. The goods were not described. The contract was made for a goods which was not in existence, which will be manufactured in future, and then later on it will be delivered to the Shubhangi. Therefore, description, the provision of description or the provision of sample will also not apply. Because Shubhangi has selected only design, not particular goods which should match with other goods. She has only selected design. This concept will be from sale and agreement to sale only. The answer given over here is correct. Simple, easy, done. Now, moving ahead, 9 questions are already done along with the concepts which relate to that particular questions. Now, question 10. State the various essential elements involved in the sale of uncertain goods and its appropriation. Now, if I talk about sale of unascertain goods, I will have to quote two sections over here, section number 18 and section number 23. Section number 18 says that if you are selling unascertain goods, matlab, if there is a contract of unascertain goods, so before selling, it should be ascertain. Now when I say unascertain, it means goods in bulk form, and when I say ascertain, that means goods are separated from bulk. And with respect to section 23, with respect to section number 23, it says that only ascertaining the goods is not sufficient. We should also appropriate the same. Correct? Easy. So the answer over here is C. First, they have specified that we should appropriate the unascertain goods. So appropriation of goods involves selection of goods with the intention of using them in the performance. And the essentials are, there is a contract of sale of unascertain or future goods. Obviously, the goods should conform, and that is matched to the description. And goods must be in deliverable state. Then the goods must be unconditionally appropriated. Appropriation is made by seller as well as buyer. That is appropriation. The dialogue over here is appropriation is bilateral act. Appropriation is bilateral act of seller and buyer. That means appropriation is done, that is selection is done with the consent of both buyer and seller, and the assent may be express or implied, and assent may be given either before or after appropriation. Easy, simple, done. Okay, fine. So 10 questions are done. 10 questions are done with your RTP. Moving ahead to 11th question. Now, this is a bit lengthy question. What I would request you guys is, please pause your videos and read the entire question, and then I can discuss with you. First, you have to read the question. Acha. I hope you have read the question now. If not, again, please pause the video and read the question first. Slowly read the entire question so that I can discuss with you. Okay? Now, I'm discussing with you right now. I hope you have read the question. I repeat, I hope you have read the question. Now, the question over here is, Mrs. Kanchan went to local rice and wheat wholesale shop and asked for 100 kg of basmati rice. Okay. Shopkeeper quoted price of 125 per kg. 125 rupees per kg. To which she agreed. Mrs. Kanchan insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such purchase. Okay. So Kanchan went to grocery store. She entered into an agreement with shopkeeper for purchasing rice at the rate of 125 rupees per kg. But before purchasing, Kanchan is saying that I want to see the sample. Easy? Now, the shopkeeper showed her a bowl of rice as sample, and the sample exactly corresponded to the entire lot. Okay, sample corresponded to the lot. Okay, fine. Now, Mrs. Kanchan examined the sample casually without noticing the fact that the sample was that of basmati rice, but it contained a mix of long and short grains. Now, sample corresponded to lot, but Mrs. Kanchan failed to examine carefully. She did not notice that in that lot of rice there was a mixture of short and long grains. Okay. The cook, on opening the bags, complained that the dish, if prepared with the rice, would not taste the same as the quality of rice was not appropriate. Okay. Now Mrs. Kanchan wants to file a suit for fraud against the seller, alleging him of selling a mixed goods and cheap quality rice. Will she be successful? The answer is no. Because in this particular question, Mrs. Kanchan is at default because she examined rice casually. I repeat, Mrs. Kanchan examined rice casually. A yes or no. Therefore, seller is not liable. Seller has not done fraud. Seller has given only that goods which he showed as a sample to Mrs. Kanchan. Decide the fate of the case and options open to Mrs. Kanchan for grievances redressal. There is no option available to Mrs. Kanchan. Mrs. Kanchan cannot claim any compensation, cannot do anything. Acha, what would be your answer in case Mrs. Kanchan specified her exact requirement? Acha, if Mrs. Kanchan specified her exact requirement, then she can sue then she can sue seller for fraud. Then she can sue seller for fraud. Now, the section over here is section 17, sale by sample of Indian Contract Act 1872. See, section number 17, they have quoted again sample, and in the instant case, in the light of the provision of subclause B, subsection 2 of section 17. Now, for a foundation student, it is very difficult to remember section like 17, subsection 2, clause B. So what my request will be to you guys will be that please remember only section 17. I am not interested in remembering subsection and clause as of now at CA foundation level. If you remember section 17, that will also do. Okay? Now, Mrs. Kanchan will not be successful as she casually examined the sample. Simple. In the instant case, Mrs. Kanchan does not have any option available to her. But if Mrs. Kanchan specified her exact requirement as to length of rice, then there is an implied condition that the goods shall correspond with the description, and if it is not so, the seller will be held liable. I repeat, the seller will be held liable. A yes or no? I repeat, the seller will be held liable. Okay, fine, done. Simple question, easy question. Now, moving ahead to question number 12. Question number 12. Ravi, we have Ravi with us. Now, Ravi sold 500 bags of wheat to Tushar. Okay, very simple. Ravi sold 500 bags of wheat to Tushar. Each bag contains 50 kg of wheat. Ravi sent 450 bag by transport and Tushar himself took remaining 50 bags. Now before Tushar receives delivery of 450 bags sent by road transport, he becomes bankrupt, that is insolvent. Now Ravi, being still unpaid, stops the bag in transit. The official receiver on Tushar's insolvency claims the bag. Now, first you need to understand this thing, that if I am an insolvent person, then my all assets will be transferred to my official receiver, and my official receiver will use those assets to settle my liabilities or to pay off my liabilities. Simple, easy, done. Now in this case, Ravi has sold 500 bags to Tushar, but Ravi is going to send 450 bags via road transport, and 50 bags Tushar has taken with himself. Now, while the goods were in transit, while the goods were on the way, Ravi came to know that Tushar has become bankrupt. Tushar has become insolvent. So the question over here is, can Ravi stop the goods in transit? I repeat, can Ravi stop the goods in transit? The answer is yes. Unpaid seller can stop the goods in transit. Unpaid seller has the right to stop the goods in transit, and this right is conferred. By section number 50 to 52. I repeat, section number 50 to 52 of the Sale of Goods Act 1930. See, 45 talks about definition or meaning of unpaid seller. Section 45 talks about meaning of unpaid seller. 46 talks about rights of unpaid seller. 47 to 49 talks about right of lien, and 50 to 52 talks about right of stoppage in transit. And in this case, Ravi has complete right to stop the goods in transit, and official receiver cannot claim goods from Ravi. Easy, simple. And if official receiver wants goods from Ravi, then official receiver should pay Ravi the price of the rice. See, they have given over here right of stoppage in transit. When the buyer of the goods become insolvent, the unpaid seller who has parted with the possession of the goods, parted means delivered the possession of the goods, has the right to stop the goods in the transit. Okay. So now in the instant case, Tushar, the buyer, becomes insolvent and the 450 bags are in transit. Ravi, the seller, can stop the goods in transit by giving a notice of it to Tushar, and the official receiver on Tushar's insolvency cannot claim the bags. A yes or no? Simple, easy, done. Very simple question. And with this, we have successfully discussed 12 questions till now, out of which 6 questions are from Contract Act and the remaining are from Sale of Goods Act. Now moving ahead, we are moving towards partnership. Question number 13. What do you mean by partnership or fixed period? So a partnership in which a particular time is fixed, particular tenure is fixed, is called as nothing but fixed partnership. Second, Can continuing guarantee be revoked under Partnership Act? Yes. Continuing guarantee can be revoked if there is any change. If there is any change in the constitution. If there is any change in the constitution of the firm. And what do you mean by goodwill? Acha, goodwill is nothing but a property. Goodwill is nothing but a property. I repeat once again, goodwill is nothing but a property of the partnership firm which allows the firm to earn profit over and above normal level of profits earned by the competitors in the same line of business. Earned by the competitors in the same line of business. See, you can see fixed partnership where tenure has been fixed, duration has been fixed. Second, revocation, yes, it can be done if there is any change. If there is any change in the constitution of the firm. And goodwill is nothing but reputation of a business which allows the firm to earn profit over and above normal level of profits earned by the undertaking belonging to the same class of business. Undertaking belonging to the same class of business. Yes or no? Yes or no? Now, moving ahead. Very simple question. Direct question, straightforward question. Okay? Moving ahead. MS ABC Associate has a partnership firm. Okay. ABC Associate is a partnership firm since 1990, where there are three partners, A, B and C, where partners in the firm since beginning. ABC are partners since the beginning. Now Mr. A, being a very senior partner, aged 78 years, transfers his share in the firm to his son Mr. Vikas, a chartered accountant. Oh, okay. So see, if I closely refer to the question till now, there are three partners ABC, out of which A is very senior. So A has transferred his interest to Mr. Vikas. Vikas is CA and Vikas is also son of Mr. A. Now Mr. B and Mr. C were not interested in Mr. Vikas should join them as a partner. Okay. So Mr. A has transferred his interest to Vikas, but B and C are not happy about it. Okay, fine. After some time, Mr. Vikas felt that the books of accounts were displaying only a small amount as profit despite a huge turnover. That means Mr. Vikas is now doubting the financial statement, the books of accounts of the firm. Okay, so he wanted to inspect the books of account of the firm, arguing that he has the entitlement as a transfer. However, the other partner believes that he cannot challenge the books of accounts. Now, the question here is, can Mr. Vikas be introduced as a partner if his father wants to retire? Now, please understand this thing. Okay? Please understand this thing. This question relates to section number 29 of the Indian Partnership Act 1932, which says that a partner can transfer his interest to other partner, and the partner who will be transferring his interest is called as transferor, and the partner to whom the interest is transferred is called as transferee. So in this case, A will be transferor and Vikas will be transferee. But since partnership relationship is based on fiduciary relationship, trust relationship, transferee will not get same rights as transferor. Transferee will not get same rights as transferor. Therefore, first of all, the question is, can Mr. Vikas be admitted, or can Mr. A transfer his interest to Mr. Vikas? The answer is yes, if the other two partners consent. That means if B and C give their consent. Second, can Mr. Vikas inspect the books of accounts? The answer is no. Transferee cannot inspect the books of account. Transferee cannot challenge the books of accounts because transferee does not have same rights as that of original partner. Section number 29. See, you can see in the instant case, Mr. Vikas can be introduced as a partner with the consent of Mr. B and Mr. C, the existing partners. And next, the right of transfer of a partner's interest. Section number 29. Again, Mr. Vikas, the transferee, cannot inspect the books of the firm. And the contention of the other partner is right that Mr. Vikas cannot challenge the books of accounts. Yes or no? Easy? Simple? Now, next is direct question again from Partnership Act. Very simple question. With reference to the provision of Indian Partnership Act 1932, explain the various effect of insolvency of a partner. Can a partner become insolvent? Yes. And if he becomes insolvent, he will have to leave the firm. This is given under section number 34 of the Indian Partnership Act 1932. Indian Partnership Act 1932. Simple, easy. Now, if a partner becomes insolvent, he cannot be continued as a partner. He will cease to be a partner from the very date of insolvency, and he will not be liable for future debts, but he will be liable for those debts or those transactions which took place while he was a partner. Which took place while he was a partner. Easy, simple, very simple. See, if you have studied Indian Contract Act 1872 nicely, then you won't face any problem in Sale of Goods Act and Indian Partnership Act. Trust me, because the language of these three acts are more or less similar to each other. Yes? Now, question number 16. Question number 16. Mr. X was introduced to the benefits of the partnership of MS ABC company with the, oh, my bad, again, Master X was introduced to the benefits of the partnership of MS ABC and company with the consent of all the partners. Now, Master X was minor. Master X was minor. I repeat, Master X was minor. Yes or no? Acha, Mr. X was minor and he was introduced to ABC and company for the benefits with the consent of all the partners. Okay. So we know that as per section 30, a minor can be admitted to the benefits of the firm with the consent of all the partners. You all know that. Okay, fine. Now, after attaining majority, more than 6 months has lapsed and he failed to give a public notice as to whether he like to become a partner or not to become a partner in the firm. Now, please understand this thing. If a minor has been admitted to the benefits of the firm, so after he attains majority, he has 6 months to decide whether he wants to become partner or not. And if even after 6 months, minor does not give public notice that whether he wants to become partner or not, then section 30 specifies that he will be deemed as partner. He will be deemed as partner of the firm. So in this case, if Master X does not give public notice till 6 months, after 6 months he will be assumed as partner of the firm. Yes or no? Okay. Now later on, L, a supplier of material to MS ABC and company, filed a suit against MS ABC and company for recovery of the debt due. Okay. So L is a supplier of the firm. L is a supplier of a firm. His dues are pending. His dues are pending, for which he sued MS ABC and company. Now, in the light of the Indian Partnership Act, please explain to what extent X will be liable. Yes, X will be liable as a normal partner, because he has failed to give public notice after attaining majority. So he will be liable as a normal partner. And second, can Mr. L recover his debt from X? The answer is absolutely yes. Absolutely yes. See, if you carefully read this, he becomes personally liable to third parties for all acts of the firm since he was admitted for the benefits of the partnership. And second, his share in the property and profits of the firm remains the same to which he was entitled as a minor. So therefore, since X has failed to give a public notice, he shall become a partner in the MS ABC and company and become personally liable to X. And since again X has failed to give public notice that he has not elected to not become a partner within 6 months, he will be deemed to be a partner after the period of the above 6 months, and therefore Mr. L can recover his debt from him also in the same way as he can recover from any other partner. Yes or no, guys? Easy, simple, done. That means X will be liable because he has not given public notice. He has not given what? Public notice. Simple, easy, done. Now, question 17, again a very easy question. State whether the following are partnerships under the Indian Partnership Act or not. They are asking that whether the given situation is partnership or not. Now, the first question is, two firms each having 12 partners combined by an agreement into one firm. Okay. So, we have two firm, firm 1, firm 2. They combined to form a new firm. Each having 12 partners. Now, you need to understand that partner can be natural person also and partner can be artificial person also. But you need to understand at the same time that partnership firm is neither a natural person nor an artificial person. Partnership firm is neither a natural person nor a artificial person. Therefore, partnership firm cannot become partner of any other firm. So in the given case, two firms want to combine and make new firm. So that means in new firm, firm 1 and firm 2 will be partner. But partnership firm is not a natural person. Partnership firm is also not an artificial person. Therefore, two firm cannot combine to make a new firm. Two firm cannot combine to make a new firm, although their partners can combine to make a new firm. These 24 persons can make a new firm, but two firm cannot make a new firm. Two firm cannot make a new firm. Two firm cannot merge into a new firm. Their partners can enter into partnership, but firm cannot enter into partnership. Although your institute's answer is little different from my answer. Institute is saying that yes, this is a case of partnership because there is an agreement between two firms to combine into one firm. But as far as my interpretation goes, two firm cannot combine into one firm. So now it is dependent. It depends upon you. It depends upon you whether you have to follow my answer or whether you have to follow your institute's answer. Strictly referring to the theory, which is given in your module also, which is given in your JKC textbook also, and it will be given in your respective study material also. Two firm cannot combine into one firm. Two firm cannot combine into one firm, although their partners can enter into partnership. So you can write reason like this, that two firm cannot combine into one firm, although their partners can enter into a new partnership, and therefore this is not a valid partnership. This is not a partnership. And on the contrary, institute has given that it is a partnership. From my perspective, I don't feel that this answer is completely correct. I don't feel that this answer is completely correct because partnership firm cannot enter into partnership. As simple as that. Now, second, A and B are co-owners, agree to conduct the business as common profit. Okay, it is a partnership because partnership is relation between two or more persons who have agreed to share profits of the business carried on by all or any of them acting for all. So yes, it is a valid partnership. Next, some individuals form an association to which individuals contribute 500 annually. An objective of association is to produce clothes and distribute free. Now again, you need to understand, partnership firm is only and only for business. Only and only for business. And distributing free clothes. Distributing free clothes is not a business. So therefore it is not a partnership. It is not a partnership firm. See, not a partnership. Next, A and B are co-owners, share between themselves the rent derived from piece of land. This is not a partnership because there is no business. There is no business. This is pure case of co-ownership. This is pure case of co-ownership because for partnership there should be some business. Receiving rent from a vacant land is not a business. Please understand. So no, this is not a partnership. Next is A and B buy a commodity X and agree to sell the commodity while with the view of sharing profits. With the view of sharing what? Profits. With the view of sharing profits. So is this a partnership? The answer is yes. 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 This is a partnership. This is a particular partnership. Partnership for single adventure. Single venture. Easy. Simple. Done. Now, moving ahead. Question 18. Discuss the condition under which LLP will be liable and not liable for the acts of the partners. Simple. If a partner is acting within his authority, then LLP will be liable. And if a partner is acting beyond his authority, then LLP will not be liable. See, simple. The LLP is liable if a partner of LLP is liable to any person as a result of wrongful act or omission on his part in the course of the business of the LLP. So if a partner does anything, whether it is correct, whether it is wrongful act, whether he has omitted to do something, but whatever he has done, if it is within his authority, then firm is liable, LLP is liable. But LLP will not be liable if partner does anything which is beyond his authority, or a LLP is not bound by anything done by a partner in dealing with a person if the partner in fact has no authority, he does not have any authority to do. So for example, a partner has ordered 1 lakh quantity of goods amounting to 10 crore rupees. So partners ordered goods of worth rupees 10 crore. But that partner does not have authority to order on behalf of firm. So in that case, firm will not be liable. LLP will not be liable because he has no authority and the person knows that he has no authority or does not believe him to be a partner of an LLP. Say for example, LLP has purchased goods from Raju. LLP has purchased goods from Raju worth rupees 10 crore. Worth rupees 10 crore. Easy. LLP has purchased goods from Raju worth rupees 10 crore. Now, on behalf of LLP, this transaction was entered by Mr. X. Mr. X is a partner of LLP who has no authority to order goods on behalf of LLP, and Raju knows that Mr. X has no authority to purchase goods on behalf of LLP. Even after knowing that X does not have authority to purchase goods on behalf of LLP, if Raju supplies goods to firm, then firm is not liable. Mr. X and Raju will see who bears the liability, but firm will not be liable. Raju can recover only from Mr. X and not from entire firm. Simple, easy. So, if a partner does anything which is within his authority, then firm is liable, LLP is liable. But if partner does any act which is beyond his authority and the other person, the third party knows that the partner is doing any act which is not within his authority, then LLP will not be liable. Easy, simple. Now, moving to last two questions. These questions are from Companies Act. From LLP, they have asked only one question, question number 18, and last two questions are from Companies Act 2013. Last two questions are from Companies Act 2013. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 and 70,000 shares in PQ Private Limited. See, understand. There is a company called as BC Private Limited. It has subsidiary called as KL Private Limited, and then there is a company called as PQ Private Limited. PQ Private Limited. Okay. Now, PQ Private Limited has 3 lakh shares. 3 lakh shares, out of which BC Private Limited is holding 90,000 shares. And KL Private Limited is holding 70,000 shares. So can I say out of 3 lakh shares, 1,60,000 shares are held by BC and KL combined. Yes or no? Now, analyze with reference to the provision of Companies Act whether PQ Private Limited is a subsidiary. PQ Private Limited is subsidiary of BC Private Limited. So, for understanding this, we will have to refer to section 2 clause 87. 2 clause 87 which talks about definition of subsidiary company. Now, a company will be called a subsidiary company if one company controls composition of board of directors of other company, or one company holds more than 50% in other company either on its own or through subsidiary. Or subsidiary company of subsidiary company will be subsidiary company of holding company. Are you guys understanding? Subsidiary company of subsidiary company will be subsidiary company of holding company. That means if A holds B, B holds C, so therefore A is also holding company of C. A is equal to B is equal to C, A is equal to C. Now, in the given situation, don't you think BC Private Limited is holding 1,60,000 shares, 90,000 directly and 70,000 through its subsidiaries. So therefore BC Private Limited is holding 1,60,000 shares along with subsidiary. Therefore PQ Private Limited is subsidiary of BC Private Limited. Yes or no? Because we will aggregate, we will apply this point, exercises or control more than one half of the voting power either at its own or through one or more of its subsidiary company. So BC is holding directly 90,000 and KL is holding 70,000. Therefore BC is holding 70,000 through its subsidiary. Yes or no? Easy. So the answer will be, therefore BC Private Limited is holding company of PQ Private Limited. Now the second question. Second question is, what would be your answer if KL Private Limited is holding 1,60,000 shares? The answer will still be same, because in that particular situation, understand how it will be. BC is holding company of KL and KL will be holding company of PQ, because KL is holding 1,60,000 shares. 1,60,000 shares, which is more than 50%. So therefore BC is holding company of PQ. A is equal to B is equal to C, therefore A is equal to C. Subsidiary company of subsidiary will be subsidiary company of holding company. Easy. See, it is given over here. In the second case also the answer will remain same. Okay, fine. Now next, Narendra Motors. Last question. Narendra Motors Limited is a government company. Okay, government company. That means in Narendra Motors Limited, government is holding 51%, at least 51%. Okay. Shah Auto Private Limited have share capital of 10 crores in the form of 10 lakh shares. Okay. So we have now Shah. We have now Shah Motors. Shah Motors. Okay. We have now Shah Auto. Sorry. Shah Auto. We have now Shah Auto, which have 10 lakh shares, out of which 5,05,000 shares are held by Narendra Motors. See, Shah Auto has 10 lakh total shares, out of which Narendra Motors is holding 5,05,000 shares. So can I say Narendra Motors is holding more than 50%? So therefore Narendra Motors will be holding company and Shah Auto will be subsidiary company. And since Narendra Motors is also government company, and we have studied that a subsidiary company of government company will be deemed as government company, so therefore Shah Auto will also be government company, because it is subsidiary of government company. So the question is, Shah Auto Private Limited claim the status of government company. Can they claim so? The answer is yes, because they are subsidiary of Narendra Motors and Narendra Motors is a government company. A yes or no? See, according to the provision of 2 clause 45, government company, if government holds 51% in any company, then that particular company will be called as government company. And 2 clause 87 talks about subsidiary company. So by virtue of provision of 2 clause 87, Shah Auto Private Limited is a subsidiary company of Narendra Motors Limited, because Narendra Motors Limited is holding more than one half of the total voting power in Shah Auto Private Limited. Now further 2 clause 45 says that a subsidiary company of a government company is also termed as government company, and therefore Shah Auto Private Limited, being a subsidiary of Narendra Motors Limited, will also considered as government company. This is actually a very nice question which incorporates two types of company: government company given under section 2 clause 45 and subsidiary company given under section 2 clause 87. We say no in Hindi that ek tir se do nishan. So this is actually a very nice question. Now this is all with respect to law in your foundation 2023, December 2023 RTP. They have given you 20 questions, all questions very nicely incorporated. Few of them are repeated questions, few of them are new questions. You can expect at least 2 to 3 questions from this RTP in your examination, either same question or question similar to this. Apart from that, with respect to amendment, I already told you in the beginning of the lecture that you don't need to worry about anything, because all the amendments are covered in your regular lectures, whether you are a JKSC student or whether you are a non-JKSC student. Yes or no? Simple, easy, done. And with this, I'll end our RTP session. All the best for your examination. May you pass with flying colors, and best of luck, guys. Thank you so much.